All right. Good afternoon, everyone. Welcome to another edition of Fire Law Roundup. Today is June 27th, 2022. And Brad, go ahead. Take us away.
Well, welcome, everybody. So today we're going to start in the grand old state of Texas, where a firefighter's termination was upheld. So the facts are interesting. They allow us to talk a little bit about proximate cause, and we'll talk about it, but it's good for a certain reason. So here we have the lawsuit was filed by a firefighter, career paid firefighter. He was terminated in 2019, and he claimed that his termination was as a result of his disability, his age, which I didn't see ever come into play in this.
Yeah, it didn't seem like it did. Yeah.
No, and although it was a little confusing anyway. And in retaliation for filing a complaint with the Equal Employment Opportunity Commission. So the short is he has surgery and he keeps having some flare-ups about his gallbladder, and he had to take narcotics, and the problems kept happening, but his employer kept accommodating any flare-ups. When he would call in sick, he'd be allowed to go home. There was no penalty whatsoever. So, however, in 2016, he was accused of attempting to obtain narcotics from another firefighter, right? So this is related to his disability, but just because it's related doesn't mean what he was doing was correct, trying to get narcotics from somebody else. So the district court then places him on a year of probation. When the investigation,
no, I think that was the department. He wasn't charged criminally.
I'm sorry.
Yeah, that was the department discipline. He was on a 1-year probation, so he got disciplined by the department.
Right. Sorry about that. Yeah, he does, and that's because of the solicitation of prescription meds. In 2017, he then says, "Hey, I'm resigning. I'm going to go to another department." But then he changes his mind, and I'll tell you what. The city here, had they known, probably would not have allowed the rescinding of it, right? Would have prevented issues. But nonetheless, they say, hey, no problem. You can rescind your resignation. And then in January of that year, 17, he was a training officer, but they revoked his position, said you're no longer the training officer. He then claims that, these are discriminatory actions. Here's the funny, and not funny part, but the really interesting part. So he goes in and to the city, he wants to copy his files and some other things. And the city employees note that he looks like he was intoxicated and appeared groggy. So they investigate and they fire him in April of 19. So at that point, now he's saying, well, look, you fired me for some reason. And what he said is, he tries to argue, well, I've been fired because of my disability. And, the judge looks at it and says, wow, the city went to some pretty good lengths to not terminate him. And they really, went to some good lengths to protect him. So they couldn't establish, the district court says that the city could not establish that there was a direct causal connection between his termination and what he was accused of. And more importantly, which I say kudos to the city documented several legitimate non-discriminatory reasons for his termination. And they did. So the point is here, the court says this, that the plaintiff failed to show the necessary causal link to prove that he was fired for age again, or disability, or for filing an EOC. And it really is good for our listeners to understand that this is what proper documentation, right, solves. And when you have here 3 potential reasons they could have terminated him or considered him resigned, here the city really did a good job at protecting themselves. And this is, again, the good lesson for the employers.
Yeah, I agree. And it was interesting. One of the defenses that he raised, I think the linking the first discipline with his behavior at City Hall, there's sort of an inference that there was some narcotics involved in what was going on at City Hall. That was the inference. And he tried to rebut that, or he tried to basically say that it was low blood sugar. Right. And that was connected to his surgery, and that was part of his disability. And the court really didn't entertain that part of it. They just said, no, the city had reason, regardless of, whatever the cause of his behavior was, the city had just cause to terminate him.
And I think we should look at one important point. My impression from reading this is if there was only one issue, if the only reason they terminated him because he appeared groggy or appeared intoxicated and there was no drug testing, I think the city would have lost, right? But I think that was just the icing on the cake because there was so much more. Because you can't say somebody looks tired or groggy or disoriented, and so we assume they're using narcotics. I think that would be a stretch. But that I don't want anyone to walk away with that impression that that's really the crux of the case. It wasn't. That was the final straw, I think, for the city.
Right. But you have your articulated reason, and then you have maybe what's motivating people to actually push the envelope. And you start looking at this, the reason why he couldn't come to work and the reason he had to leave work early and so on was due to pain. And it was due to the fact that to deal with the pain, he had to take the narcotics. Right. And then he's trying to solicit narcotics. And then we've got this kind of bizarre behavior. And you start putting so whether that's the articulated reason or not, I think that's sort of in the background. I think that was the crux of his case. He said they're discriminating against me on that perception. And the real reason is low blood sugar. And the court said, you know what? They had legitimate grounds to terminate. So interesting case. Interesting. He also applied when he came back, he immediately applied for the fire chief's position. The fire chief's position was open. He was passed over. And then there was a couple of other promotions and he was passed over for those. So that was part of his retaliation claim as well. And the court, again, like you said, he wasn't able to connect the dots to say that either retaliation or his medical condition or his age was the cause for the city's decision. So,
exactly.
Interesting case.
Let's stay in Texas. Now, usually I do not, you and I are very good about not giving opinions, but I'm going to break that rule right now. If you sit in your car, and especially you're a captain, but if you sit in your car on the fire department driveway and you wave a handgun at two of your subordinates.
Well, they probably deserved it, Brad. Let's face it. They probably
right. If you wave a handgun at people, especially these days in Texas, right? But nonetheless,
he's lucky he didn't get shot back.
I'm surprised he didn't end up dead in the front seat, honestly. But nonetheless,
it's sad. We shouldn't be joking about it. It's somebody's career here, but
it is. And look, he was having a bad day, but that was part of it. He reported that he was upset that day, and being upset and a handgun doesn't go well together. So he's I like your note in the blog that that's a Texas way of saying that he's been fired, but he's on a long unpaid leave.
Yes, suspended indefinitely. That is a Texasism for terminated.
So okay, now let's go to FDNY. Let's come up to New York, and here we have FDNY where an EMT alleged disability discrimination. So let me talk. Look, I'm a big fan of this. Is FDNY EMS, right? Which is part of the FDNY, but it's the ambulance. They're not firefighters. There's been a lot of discussion during COVID about the FDNY, and especially the union came out very much against vaccines. And there was a study that showed a very small number of FDNY EMTs were in fact vaccinated. I don't know if you had seen those.
No, I hadn't. That's crazy. I mean, who's in a worse situation in terms of exposure than them?
Yeah, and I know a number of FDNY EMTs, and 1 out of maybe 8 or 9 of them decided to get vaccinated, and it's a pro-union type thing, I got to say, I think, but crazy. Yeah. In any event, look, this is a suit which has been dismissed. A suit alleges disability discrimination based upon a perceived disability. And this is a little screwy. So here, the FDNY EMT, she was terminated in April. She's now filed suit. So this is very current, and again, not dismissed, just filed. And she says, the city perceived I had a disability, and this is what will get interesting, which disability. because it's, well, I'll go through it. So she claims, and by the way, just so no one gets confused, the ADA, Americans with Disabilities Act, prohibits discrimination based upon an actual or perceived disability. So the claim states a cause of action properly, that you can't perceive that I have a disability and then take negative action against me. So what happens is in September 21, the city allegedly, right? These are all allegations. Let's be real clear, allegations, not a court finding. And the city, according to the plaintiff, starts regarding her as having a disability of a contagious disease. I think you made reference that we believe it's COVID, but it's kind of hard to figure it out what it is. They make a record of that disability by misclassifying her as being substantially limited with an impaired immune system. We really don't know what it is.
Yeah, I think as best I can get, they're alleging that her lack of having a vaccine is indicative of her having a compromised immune system. So I think that's I think it's creative lawyering, okay, right, on the part of her attorneys. But what they're saying is that they're treating her as having a compromised immune system because she didn't get the vaccine.
Yeah, and I got to tell you, the first time I looked at it, I'm like, wow, that is pretty creative. But I don't think it's going to fly. But nonetheless,
yeah, right. Well, that's a different issue. Yeah, if it's going to fly. But look, at least if we can understand what she's saying, that's at least a first step.
And I think a judge is going to look at this saying, why aren't you being clear? You have to state what the disability is specifically. And but again, creative, kudos to creative lawyering. In any event, so they then go on to say, despite having knowledge of plaintiff claiming protective status. Now, so that must mean that the individual said, I assume I'm not getting the vaccine. I'm putting this into it. She must have told them I'm not getting it. And then she said, well, but you then treated me as somebody with a perceived disability. The complaint doesn't really do a good job of saying what the impaired immune system is, but I agree with what you said, because the complaint does go on to criticize the vaccine. The COVID vaccine is not working as being, at that time, it wasn't approved by the FDA. And frankly, well, different issue, but I don't think anyone should have ever forced anybody to get a unapproved drug, which is still experimental, though approved for emergency use. I think it's a very bad precedent. In any event, still, she really attacks, look, you're looking at me, my status as being unvaccinated as a disability. I just don't think that's going to fly. I don't think that's a disability.
Well, is it regarded as? And I think that's, they've couched it as they can go under the regarded as. So if you think of the ADA protecting, you mentioned this, right? You can have a disability, or you could be regarded as having a disability. And that's still a violation even if you don't have a disability, if your employer treats you as having a disability. And that's what she's alleging. She says, I'm being terminated because they don't think my immune system is robust enough because I didn't get this vaccine.
And look, I was trying to think of similar situations, and I could only go back to the HIV cases in the 80s and early 90s, where people would say, well, you look like you have HIV, and they would take action against them. There are a significant number of those cases, and it was kind of, based on how you look or how you are, whether you have the disease or not, we perceive you as having it. But that was perceived as actually having a disease. Here, we're not perceiving you as having disease, we're perceiving you as being susceptible to the disease. And I think that's very different. I think
right. No, I agree. And I think that's the city. Well, you just made the city's argument.
Yeah.
Okay.
Yeah.
Her argument is, no, the disease isn't COVID. The disease is my compromised immune system, quote unquote, my compromised immune system. Now you say, well, how is your immune system compromised? Because you didn't get the vaccine. Because you didn't get the vaccine, Yeah. I know. This is lawyer's version of calculus here.
It is. It's impressive. And look, everything else is lost. So kudos to the attorney, right? You got hats off. Okay. Yeah. So lastly, wow, we're on number 4. retaliation.
We got two more, I think, but
okay.
Yeah,
Hopefully I do. Okay, so let's go to LA. We don't know much about this. This is in LA where a retaliation suit has been dismissed. We don't know whether this is because of settlement. There's certainly no court action.
You know
we don't know what happened.
Right. Well, let's go through the facts, and I don't think it's because of settlement, but that's just my perspective. But go.
Yeah,
go
I'll tell you my thought, but I don't know if I want to guess. So here, a probationary firefighter. Start there, right? A probationary firefighter could be fired for any non-discriminatory reason, right? And it's not hard. In any event, he filed suit in 2020. He said that he was terminated for complaining about hazing and harassment, and for some reason, he agrees to dismiss his suit, but he doesn't complain. What's really interesting is he says, I need psychiatric treatment because of what's going on. He gets it, and it's his psychiatrist, almost a Tarasov type ruling. Our listeners don't know what that is, but his psychiatrist picks up the phone and calls the department, says, you've got to investigate. I won't go as to privilege and confidentiality issues or whatever, whether there'll be a claim against a psychiatrist at some point, but nonetheless, that's when he said the retaliation began. So the hazing happened, he gets psychological treatment, and then he's getting retaliated against after his psychiatrist or psychologist calls. The retaliation, he says, is resulted in him being singled out for drug testing without cause, merely because he was tired and recovering from an illness. And then he's shortly fired and claims shortly thereafter he's fired and claims I don't have a reason for it, so I don't know. But here all we know is, and here's what gives me the suspicion, right? He was sent for a drug test after appearing to be unfit for duty. He's now terminated 30 days later, and one might assume that that drug test maybe didn't turn out the way he would have liked it to happen. I don't know. We have no facts other than to guess.
Yeah, they went for the information in the file was not clear as to that. So,
right. I am looking. Let's see. There's one. There's two. There's three. There's four. I only see four. What is there a fifth one? And if there is, I apologize because I'm not seeing it.
Oh, you mean you're done with this one?
Yeah. So that's four of ours. And I got to tell you, we went through these pretty quick.
Yeah. No, we did. Let's the LA one. It's not clear whether or not there was a settlement. The reason why I tend to suggest there's not a settlement, that usually when both sides come together to agree to dismiss a case, both attorneys will sign off on it. Right. And that's sort of an indication to the court that, okay, we're all set. This was not. This was only the plaintiff's attorney that signed off on it. So
results.
But again,
put in front of them.
It's possible, another attorney's out of the country on vacation, whatever, they can't get his signature. And so one party goes forward. So there could be a settlement, but it raises a question as far as that goes. So we don't really know why. All we know is that the case is being dismissed. Okay. And yeah, the last one is it has to do with I was going through the cases, and every night, for those of you who aren't familiar with what I do in my spare time, but I'm reading through the cases, and I have a service, Lexus, which gives me they basically deliver to my inbox, all the cases that involve fire departments, or at least mention fire departments. And the first four I read, all of them were police cases where police apprehended someone. The fire department got involved because either the person resisted or the person needed to be restrained, and medics were on the scene and they assisted. But the bottom line is fire departments were involved in the apprehension, and there was a lawsuit. Now, the fire department was not named in all of the suits, but it just triggered in my mind the fact that, boy, these cases seem to be increasing. And so I went back and I queried my database, and I tried to I did it a couple of different ways, but I took a 7-year period from 2007 to 2014. And out of roughly 1,500 civil cases in which fire departments were named as defendants, and by the way, probably 800 of those were employment related. They weren't incident related. The other 700 or so probably even less than that. But not all of those 1,500 were incident related, my point. But out of those 1,500 cases, only 3 cases involved situations where the police were involved, where we were assisting the police on the scene with an incident. Compare that now to the last 7 years. In the last 7 years, there's been about 1,300 suits, 46 of which involve EMS units on the scene assisting the police. That is a dramatic increase. We all know about George Floyd and Michael Brown, and there's just been an explosion of lawsuits against police, but many, many times fire departments are getting dragged in. And the reason why I highlighted this is that, when we engage in high risk activities, we need to really have our antenna up. We need to be alert. And if assisting the police was not already on your radar as being a high risk activity for liability anyway, and I think I always knew responding to assist the police was high risk safety wise. But here we're saying, no, this is one of those high risk areas that we've got to be paying attention to. It may not have been high risk liability wise 10 years ago, 15 years ago, certainly 20 or 30 years ago. It is today, because we're in the target acquisition range of plaintiffs' attorneys in these arrest cases. And we know it on the ketamine.
Look, you gave a great lecture at my conference last April on right to force entry into buildings and search and seizure and plain view, and this fits into that as well. And the ketamine ones you just talked about, cases, that we're giving ketamine to restrain, and we get in this hero mode as EMS and firefighters, like, oh, we're going to be the cops, we're going to use force, etc. And it really does hurt us. Curt, I hate to do this to you, but I have somebody staring at me who I'm unfortunately.
Who is it? Is it Nicole?
No, it is not. It's a contractor who's sitting here tapping his wrist and showing up early.
Okay.
But,
doesn't he know there's thousands of people listening to us?
I know, and I am trying. Like, see, wait.
Okay. Now I think we're at the end, and
great.
And that's gonna wrap it up for another edition of Fire Law Roundup.